I won't bother going back through that. I see we have all members of the commission present. Let the minutes reflect that the meeting was called to order at 7 p.m. Third item on our agenda is minutes of meeting number 1751, March 19th, 2024. What's the commission's pleasure on the minutes?
Mr. Chairman, I make a motion to approve the meeting minutes for meeting number 1751 from March 19, 2024, as written and submitted.
Motion to approve by Ryan. Thank you, Ryan. Is there a second?
I second the motion.
Seconded by Gary Belkey. Thank you, Gary. Any discussion on the motion?
They look good to me.
Yep, me as well. Anyone else with any items? Okay. Hearing that, all in favor of the motion to approve?
Aye.
Aye.
Anyone opposed? Hearing none, the chair votes aye. Motion is passed unanimously.
I would just like to know that I abstained since I was not present.
I'm sorry, one abstention. Item number 4 on the agenda, public comment. Anyone from the public wish to make a comment this evening? Hearing none, we'll move to item 5, correspondence. Clifton? No correspondence. It's a fairly bland agenda thus far. I'll try to do my best to keep it that way. I'm not trying to steer the meeting, John, at all, but
Bland is fine with me.
I know you're used to a big following at your meetings. I hope you're not too disappointed by the low turnout tonight. 2 reports from staff.
No reports.
Anyone on the commission? Please don't be hindered by my prior remarks. Okay. Zoning enforcement violations that stand out that require discussion? None. No matters for administrative review. We move to old business. No items under old business. Takes us to public hearings. Lynn, would you mind reading the legal notice, please?
That's okay, Lynn. You can just read the,
Sure.
Just read the
Okay, so we'd like to open up the hearing for PZ 2403RA, J&H Mystic Hospitality, zoning text amendment application for changes to ZR 8.1 and ZR 8.6.1 to include revised frontage and buffer requirements applicable to the tourist commercial TC 80 zone.
Thank you, Lynn.
Yep.
I see we have Attorney Casey here. You represent the applicant?
Yes. For the
Please
record,
proceed.
thank you, Mr. Chairman. For the record, my name is John Casey. I'm a partner with the law firm of Robinson & Cole, and we represent the applicant, J&H Mystic Hospitality. We're here tonight to propose a reasonable and common sense text amendments to make requirements for setbacks along the I-95 in the town and your commercial zones consistent, to eliminate unnecessary buffer requirements that impose restrictions on reasonable redevelopment in the TC80 zone, and to accurately reflect the existing built environment in the TC80 zone, where many parcels, not that there's many of them, do not have conforming buffers or setbacks along property lines that abut I-95. So as I said, the applicant is J&H Mystic Hospitality, LLC. They are the owner of the Howard Johnson Mystic Diner property. They intend to improve the hotel, redevelop it. If you've looked at it closely, you can see it's a little tired. They would rebrand it and improve the site, including fixing up the frontage along Route 27. There's an odd little right-hand turn in, then there's an intersection, and they're in discussions with DOT to get rid of that first little turn in. So we think it'd make it a little more consistent. But I don't want to get the cart before the horse. But that's why we're here, because as we went through the process of designing the site and applying the regulations to the site, we came across the buffer requirements and sort of an inconsistency as to whether I-95 counted as a frontage, like a front yard. So we thought the best course of action was to come to this commission and seek amendments to those for clarification. Because as the buffer requirements now stand, well, I'll go in order in terms. So in the bulk table now, 8-1, there's a footnote that says, sorry, get it? That I need to remember to bring reading glasses to these things. Where is it? That frontage abutting Interstate 95 and Route 78 shall not be considered street lines for the purpose of determining yard setbacks and frontage. The footnote, though, only is in a line for the TC 80 zone. I'm sorry, the HI 60 zone, and it seems the reasoning for having it in the HI 60 zone applies equally to the TC 60 to TC 80 to not require large front yards along I-95. I don't think anyone would consider I-95 a road, a street, like you would consider any other street in the town. So the first amendment is to just simply add the letter A in the table so that that footnote applies to the TC 80 zone as well. There's also a proposal to, the footnotes were missing the letter I. So we noticed that, we noticed half of it, sorry. We noticed that I was missing, so we proposed to change J to I, but we didn't realize that there is a J in the table, in the PV zone under maximum height is a J. So I think as a scrivener's, you can fix that as a sort of scrivener's error. So we just, I'll give credit to Clifton for pointing out the J in that PV5 zone line. The second part of our application is to amend the buffer requirements. So your regulations for some zones have very specific buffer requirements, but in the TC80 zone, it's just three very generic statements. 50 feet with 25 feet of screening except front yard, 50 feet of screening adjoining hotels, except in the front yard, 100 feet with 50 feet of screening adjoining existing residences and residential zones. So the issue there, and maybe I'll take this opportunity to pass out an exhibit to discuss. I'll stop talking while I pass this out.
Thank you, sir. So, looking at the zone, it's a fairly small zone. It's at the interchange where Route 27 meets I-95. And the need for buffers in general, and this is in our application, I'm trying not to just repeat what I wrote in my application, but in general, you're looking to protect less intense uses from more intense uses. And the buffers have to go on the more intense uses because they're the ones that are more likely to bother the less intense uses. So here, when you go to redevelop, you'd have to apply the existing regulations. For the Howard Johnson's property, that was built before buffers were required and really never accounted for having to put in a buffer. So what we're proposing
is to say that the 50 feet with 25 feet of screening doesn't apply in the front yard, or for property lines that abut Interstate 95 and/or its on or off ramps. So what I handed to you, this exhibit, is your zoning map. It shows the entirety of the zone. The blue lines is basically where that rule would apply. So it's if you start in the bottom left, it's the rear property line for the hotel, and that's adjacent to the Howard Johnson's. It's the side/rear property line of the Howard Johnson's property. It's the old Mystic Village boundary line. It's the aquarium boundary line. It's the property that abuts the off-ramp on the north side, coming south on 95. And then it's a property along the highway near the other hotel. That's really like a flag lot, which is actually only, the stem is only 60 feet wide according to the GIS. So those are really only where the only places where this would apply. And then we also propose to say that the 50 feet of screening for hotels would not apply when two hotels abut each other. And honestly, this is really only one spot in the town or in this zone, and that's between the Howard Johnson property and the property to the south. There's currently no buffer there. And in a minute, I'll get into the considerations. And one of them being, we're asking that the regulations reflect the actual built environment. So before I get to that, just generally, you probably know this, but as a commission, you are free to approve amendments through your legislative capacity. And the Supreme Court of Connecticut has said, or has recognized this power when it's held that a zoning commission is free to amend its regulations whenever time, experience, and the responsible planning for contemporary or future conditions reasonably indicate the need for a change. So there's no standards like when you're dealing with a special use permit or when the zoning board's dealing with a variance. This is really, you have a lot more discretion in doing so, in passing on these amendments. In your own regulations, talk about the impact statements that must be submitted, which we provided, including that the proposal is consistent with the Plan of Conservation and Development, that it's consistent with the comprehensive plan, and that it conforms to the general zoning purposes set forth in section 1.1 of your regulations. Again, I don't want to repeat what I put in my application. I'm happy to speak to any of them. I'll just note for the record, and maybe if you're interested, so consistency with the Plan of Conservation and Development. The Supreme Court and our statutes recognize that you want to have your, obviously, text amendments consistent with the Plan of Conservation and Development, but in the end, the POCD is advisory only when it comes to text amendments. And so, that being said, we still go through and point out where different sections and policies in the Plan of Conservation and Development would be met by this, including section 10.3, which talks about maintaining and supporting businesses that are already here in the town. Policy 10.4.1, that the town should, quote, promote economic drivers, including not limited to tourism. We feel that removing the buffers and taking away some hindrances on redeveloping properties in the zone would help enhance tourism, because this is the tourism district. So we have a statement about consistency of plan of development. We have a statement about consistency with the comprehensive plan, which is defined as the existing zoning map and zoning text. We're not intending to change any of the boundaries of in the TC80 zone. We're not proposing to change any of the bulk requirements, except for these very specific ones concerning buffers along I-95 and between two hotels. So we feel that we're not disrupting the plan, the comprehensive plan when it comes to development in the TC80 zone. Lastly, conformance with the general zoning purposes set forth in 1.1. I would say, we put this again in our written submission, that the proposed amendment, so it includes changes to the development standards zone only, so it doesn't affect the entire town, it affects only one small zone, and it would not impact any other zoning districts. And then all the bulk and dimensional requirements in the zone will remain the same, as I said, except these very specific ones. And going through my notes, and I'm trying not to repeat myself because it is a very targeted amendment. You know, the exemption only applies to the buffer requirements along I-95. So going back to a point I made earlier, buffers being appropriate to screen a less intense use from a more intense use, the requirements for buffers between commercial uses in the TC80 zone and residential neighborhoods will remain. That'll still be the same. Really, not to be too facetious about it, but just getting rid of the idea that a property owner in town has to screen their commercial use from people driving 65 miles an hour through Mystic on the highway. I just feel like that's not necessary to promote development in the town. It actually, as I said, sort of hinders development. We don't need to protect those people on the highway from viewing a hotel or viewing Old Mystic Village or viewing the aquarium, which this, as written now, these rules could require, if any of those uses, other uses came in, could possibly require that they somehow come up with a 50-foot buffer along I-95. So we think this, as I said, reflects the actual built environment. On what I submitted to you, it didn't print out great, but there's really no buffer for I keep wanting to say the seaport, the aquarium and Old Mystic Village. Their uses are right up to the boundary line. And I don't expect those to change. So I think it's appropriate for the regulations to reflect what's actually there and what I think the town would actually require going forward. And so with that, I think I will end. I would just ask that you, thank you again for your attention, trying to keep it quick, although typically my projects do not go very quick. But we would say that it's given that it only applies in the TC80 zone, it only applies to a small area town, it only applies mainly to property boundaries along I-95, and that it's consistent with the zoning regulations, the plan of conservation and development, and I guess most importantly, the actual pattern of development that's taken place. We would ask that you approve this amendment as submitted.
Thank you, sir.
Yes. And happy to answer any questions.
If I may, could I just clarify what your proposal was? Your amendment that you submitted had that footnote letter correction?
We had it in one place because it went HJ.
Yeah.
And we thought, oh, well, it should go HI. in the list of footnotes, but we didn't notice that there was actually a J in the
Right.
table.
Right, so would you, if we were to approve this, could we just ignore that part?
You could
Would we
just
put a
ignore it and
stipulation
just,
in
yeah,
for that?
yeah,
Yeah.
yeah.
Okay.
Or, as, I would suggest to my commission that you could just, the next time you were, if it was in the old days and you were, printed off 50 copies of your amendments, your regulations, every 6 months, that the next time you printed them, you could change the J's to I's because
Sure.
it's not substantive, so.
Yep, okay.
But to leave it the way it is, because it maybe wasn't fully noticed.
It doesn't seem very important, I just
No,
wanted
no,
to make
and
sure it wasn't
again,
something to trip over.
It's kind of a silly thing. I apologize that when I was looking at the whole thing, I didn't pick up that there was a J already there, so.
Anyone else with any questions?
Yeah, I have a couple of questions, not on your proposal, but, so I'm looking at the map that you put out, and the TC80 zone includes Clara Drive, and it includes the hotel that's on the hill, and then it includes the property behind that hotel on the hill that came
Yeah.
before us
Yeah,
a few years ago. And so your text amendment in red that says, 50 feet of screening adjoining hotels except in front yard, minimum buffer requirements shall not be required for a hotel use that adjoins another hotel use. It's not just about the lots that are on 95. So I think I just want to point that out. And I don't know if you considered that at all?
No, I did, but because there's other hotels, there's 7 hotels in the zone, but none of them abut each other like the Howard Johnsons, and I'm sorry, I'm blanking on where Andiamo is.
Yeah, I know where it is, yeah.
Yeah, none of them abut, so like the hotel, like one of them the one that fronts on 27, and then the one that's on Coogan, their property lines don't meet, so that wouldn't apply. So you have the vacant parcel kind of in that corner. So I guess if someone was to propose to build that as a hotel, then the buffer wouldn't apply, between those, the 3 hotels, the new hotel in the corner, and then the one, one facing Coogan, one facing Route 27. But since that's not developed yet, I didn't want to put it on there to, that's a possibility that there wouldn't have to
Right.
be buffers between there.
And that's my point.
Yes, no, I agree with that.
it
If
does
that
not-
parcel is developed as a hotel.
Right, which was the original proposal that came forth a few years
Yeah.
ago, and I believe it. So,
Right. But I would say
I
that
don't
only
think
hurts.
it's limited to 95 or, and just existing hotels.
Right.
Also, there's been a number of times when Old Mystic Village has been discussed. There's been discussions on hotels in that village. And so therefore, there's another opportunity for development without buffers based on the proposed text amendment. So I just, I'm not sure that we're just talking about the existing Howard Johnson and whatever the hotel is next to it.
Yeah.
I think that the text amendment in red expands the scope when looking at the entire MAD zone.
So we wrote it in a way that it shall not, so it says that the minimum buffer requirement shall not be required for a hotel use that adjoins another hotel use. So
Right,
I think that's limited, so if someone was to put a hotel in the middle of Old Mystic Village, setting aside all the pre-existing complications that that site has, I would say that that's not abutting another hotel use. Because there's no hotel that abuts Old Mystic Village.
At this point, there's no
Right,
hotel
well,
there.
but I don't know that there ever could be, because really
Right.
Old Mystic Village, you know, it has Coogan, it has
Mm-hmm.
the aquarium, and it has I-95.
So you're looking, so I'm just pointing out, you're looking at today's picture, not a future picture of possible development in that area. That's what I'm
Correct,
pointing out.
yeah.
Okay.
But I'm
Thank
also, so I want to, one of the issues is, you know, reflecting the existing built environment, but I also think reasonably, you know, the aquarium's not going to go away. No one, I don't think that's going to turn into a hotel. And all the other, most of the development in that zone is pretty well set. There's one vacant parcel, and I agree that if that's developed into a hotel up at the top of Clara Drive, then they wouldn't need a 50-foot buffer between it and the two hotels, but they would need a buffer going south. Because remember, this only says you don't need a buffer between the two uses, not around the entire parcel.
If, it's not directly a comment for you, but to Lynn, you know, I liked the note that Clifton had in the planner's report. Just, you know, it's a seemingly minor revision, but he found a silver lining in removing the buffer between hotel requirement and that they could share parking and reduce impervious surface, or they may be interested in doing such a thing. And, you know, my opinion, where one parking lot ends and another begins between hotels, I'm not sure.
I think we can maybe talk about that when we close this section of the meeting. I'm just pointing out and making sure that you understand
Yep.
that what you're proposing
I think it's a valid
is
point.
not,
It's a valid point.
yeah.
Yeah.
I-
No, no, and
Since we brought up prior developments, and it was a fairly recent one,
Right.
an extensive engineering was done on that hotel. It had issues with stormwater management, because of the tremendous slope getting back down the hill to Coogan Road. There was all kinds of special energy dissipation and infiltration that was required. And they never really got by all of the difficulties associated with that. You're right, there were a lot of concerns associated with that. There was also issues with both wastewater disposal, again, because of the tremendous head going down the hill, the velocity component of that water causing problems in the sanitary sewer system. There was also a problem with fire suppression. Water pressure, because that's on the top of a much higher elevation, was most likely going to require some sort of a storage and pump system. It wouldn't work with just the jockey pumps that they had proposed. So there were three major issues associated with that were never really dealt with. And any one of those three could cause serious concerns for another hotel development. So I think unless conditions change out there substantially with regard to any one of those three subject areas, it's a pretty high hill to climb, literally and pun intended there, to get by those issues on that side for another hotel. Anyone else have any questions of the applicant? Mr. Philbrick?
Gary, go ahead.
Have you talked to the neighboring hotel?
You know, we didn't. We know they have plans, and their renovation, they actually were approved recently.
Yep.
They don't show a buffer. My understanding is because they were able to keep their redevelopment, you know, a little less intense maybe than what my client wants to do. So they were sort of able to avoid having all the new regulations apply to them. That was my understanding from reading the approval.
Okay.
But my understanding is that they they work in concert with each other. And there's one, and they are, and I apologize because I know the engineer has been working on the entranceway, that serves both parcels.
Yep.
So I know they're discussing it. I guess I'm not prepared to talk about how everything will work out there, but I know that there's no buffer there now. There's really no buffers proposed on the parcel to the south, and so I guess
Any
this
further
should,
questions, Gary?
Nope.
Ben?
Thank you, Gary. To follow up on that, and excuse my ignorance, but so the text amendment, you don't need to notify the abutting property owners with a registered letter? Okay.
yeah.
Because that was my main concern with Gary's, is that will impact Mr. Middleton's project immensely. And you have had conversations with him?
I believe the principals have, but
You haven't?
I have not.
Okay, thank you. Lynn?
So you alluded to the size of the project of your client and this, saying that it was substantial. What are those plans?
The hope is to add a third floor. Same footprint, third floor, which we can do with all the bulk requirements and the setbacks, especially if we confirm that the highway is a side yard and not a front yard. And they'll configure the parking a little bit, and sort of change the entryway, it's basically in the same footprint. I've seen only preliminary things for now, but as we, looked at the issues, the buffer jumped out immediately, because you would basically, as you go around the backside of that property now, if you had to take 50 feet, you would take 50 feet buffer is bigger than the 25-foot side yard setback. So it just meets the side yard setback at the very back corner of the building. And if necessary, we could cut off the corner of the building, at least for the third floor, because obviously the first two floors are pre-existing. But we couldn't, we can't fit 50 feet of buffer where we only have 25 feet of side yard setback. So we either needed to go for a variance or propose a text amendment.
Thank you.
If no one has any other questions, I have just a few. The I-95 barrier or boundary lines are not really highway lines, they're not really street lines. They're non-access lines. And the rights of access were purchased when the property was originally taken for I-95. And non-access lines are entirely different than street lines. They don't permit access of any sort. The access rights were purchased when the land was bought. Does that change in any way any of the language that you have reviewed and require any additional language, because these are non-access lines and not street lines and not highway lines?
So I had a conversation with Clifton, and he can speak for himself, but if we were just dealing with like whether this is a front yard or a side yard, we had sort of come to the conclusion that it's a side yard because it's a non-access line.
Right.
And if that was the only issue, we probably would have been able to go forward with the with special permit
That was
application.
my next question. Doesn't
Yeah.
that really solve it? No?
It doesn't solve the buffer problem. So then we had the buffer problem.
Okay.
And so really,
I get
we're
it.
here for the buffer, and we figured just throw in, that footnote to make it clear that in this zone, because you have the footnote for the highway interchange zone, we figured, and that might be a relic, it may be unnecessary, but if it's there to make it clear, why not add it to the tourist zone?
And no other changes in the language are required because these are non-access lines?
No, because that would be a side yard. We're okay on the front yard, we're okay on the other side yard to the south, so we don't need any other changes.
Okay.
Yeah.
I think that addresses both of my questions. So, Clifton, any reports that you want to make during the public hearing portion of the meeting?
No,
have your comments,
I think
your recommendations.
John answered the comment perfectly based off our discussion. The definitions within the regs also would have identified the lot as a corner lot based off of its layout, which would have impeded the buffer requirements anyway. So this really became more of a buffer issue than how to classify the yards. The only thing that's missing in my report is the comments from the police commission, which their meeting was Thursday of last week after I sent out the report. They had no comments on the proposal, no concerns. So where it just says awaiting comment is no comment from the police commission. Other than that, I thought it was a pretty straightforward amendment. This doesn't have a large radius of impact just because it's the TC80 zone, so there are very few properties concerned. Overall, no comments from me.
Thank you, sir. Anyone have any questions of Clifton?
I think, there you go. So Clifton, is there the possibility, you know how sometimes there's a proposal and we kind of amend the proposal as we go along rather than reject the entire proposal? Is it in our purview to approve the proposal except for the proposed language in 8.6.1B? Is that a possibility via the group?
In terms of this proceeding, yes, that would be
Okay.
a possibility. I think the applicant may have some concerns on that just with how the future project would go. But yeah, it's completely within your purview to do so.
Okay, thank you.
No other questions? Then we have, at this point, we'll move to, are you finished, Attorney?
Well, not that I'm a mind reader, but in terms of that comment, as I read the language, our intention was that the buffer requirement wouldn't apply on property lines where two hotels abut. I can see as you read it, it says it should not be required for a hotel use that adjoins another hotel use. I think you could amend that to say along the property line between, I can't really wordsmith it on the fly, but if that would solve the issue. We don't intend for it to say that there's no buffers around any hotels. It's only along the property lines where one hotel directly abuts another hotel. That's the intention there.
Okay. Any further comment? Then we'll move to the public comment section of the public hearing. And everybody here is familiar with the rules, so I'll just paraphrase them. We don't have anybody who signed up to speak in favor. This was withdrawn or against. This was withdrawn before you came in, Carleen, so anybody can speak at this portion, during this portion of the meeting. But you can speak either in favor, against, or make a general comment. The applicant will be given time for rebuttal. Anyone who spoke in favor or against will be given time for rebuttal to the answers, and it will go back and forth until everyone has spoken and no one wishes any further input. So with that in mind, and no one having signed up, Ben, I saw you had your hands up, so please feel free to take the mic, sir. Good evening to you.
Thank you, Mr. Chairman. For the record, Ben Tamsky, 5 Edgemont Street, Mystic. Unfortunately, I thought that I had downloaded the staff report, but I hadn't, only the first page, so I cannot refer to the specific language and the numbers of the requested amendments. I don't have any problem with the amendments for the buffers along the highway. I think that's appropriate, and it reflects the built environment, as Attorney Casey pointed out. I think the language for the buffers between the hotels is another story, though. And I think that commission members have brought up some possible problems, and I worry about unintended consequences. down the road. I will point out, and Attorney Casey can correct me if I'm wrong on this, but my research told me that the vacant land at the top of Clara Drive that was proposed for 2 hotels a few years ago was also J&H Holdings, the same owner. So I think that there should be some clarification there, just for in the interest of full disclosure. The fact that the applicant has not spoken with their direct neighbors, I think says a lot. I just think that, I understand the idea that perhaps, as Clifton said, it could lead to less impervious surface by sharing parking and so forth. It could also lead to more, just more density. If you start doing away with buffers, I think you could be opening up the possibility of greater density with greater parking and greater impervious surface. So the applicant has a very simple solution to their problem, which is ZBA, which is what it's made for. And if it's a situation where it's an existing condition and they can prove a hardship based on that, then they'll get a variance for it, and they can go ahead with their project and everybody will be happy. But I think that we should be very careful with that, doing away with the buffers between the hotel uses. Thank you.
Thank you, sir. Anyone else wish to desire to speak on this application? Does the applicant wish rebuttal time?
Just briefly, we feel that the impact of removing the buffer between 2 hotels is minimum, and actually, as with the buffer along I-95, reflects the built environment. There's no buffer between those 2 hotels. And they've managed all these decades quite well. So we feel it's excessive and unnecessary between 2 hotels. We think it's limited. There's, as I said, there's not a lot of parcels in this zone. There's, I think, just one potential for hotels, another hotel, but as the chairman pointed out, there's significant issues with that property. I do know that it's owned by the same company. We do not represent them in connection with that property. We weren't involved in the prior proposal. We didn't represent them. I have no idea what was proposed. I've learned more about it tonight than I did. I knew what I read in the paper all those years ago. So this isn't an attempt, really. It has nothing to do with the parcel on top of the hill. This is very specifically related to the Howard Johnson parcel. But we feel going to ZBA is not appropriate if there's a reasonable text amendment that would solve the problem. Really, you should set your rules in your zoning regs and not zone through variances, which have to meet a hardship requirement.
Can you think of any hardship that you could argue in this case that's related to the land and would qualify as a valid hardship?
There's a
Parcel shape, maybe?
Partial shape. There's a theory that if you request a variance and you kind of make it more conforming than it was, if it's already a non-conforming issue, you might be able to get a variance that way. That's your hardship. It's not necessarily a hardship, but you're making it better than it was. But with any commercial development, I think you'd always run the risk, and I don't want to have my words used against me, depending on how tonight goes, but you always run the risk that someone, you're just looking for financial benefit and you don't have a legal hardship. So I don't know. I really haven't, fully researched it. We've focused on going forward with the text amendment, and we thought it was a simple, low-impact text amendment.
True hardships are usually very hard to find in cases like this, but parcel shape might be one that you could argue.
Well, you could argue that if
I
these were,
can't think of anything else.
if these were imposed after it was built, it's, if you had to put 50 feet on either side, you'd use up almost half the lot width
Right.
on buffers. So,
I would just add that as a matter of practice, the zoning regulations should be to mitigate the application of variances, not to expand them.
Thank you, I agree with that.
But I did want to add, I did some wordsmithing to alleviate Lynn's concern for that 861B. So, potentially, if you close the public hearing, I can share that as well.
Thank you, sir. Does that conclude your rebuttal?
yes, and I would just say, for the record, before I am prohibited from saying, I think modifying our proposal along the lines to clarify where the buffer doesn't have to apply between two hotel uses would be within the scope of the notice and the proposal as it was put in the newspaper. So I think it would be within your discretion to modify it along those lines.
How would you feel about adding the, does not apply to the zone boundary lines as well?
I see no problem with that.
Okay.
Right, you're along the edges. And
Right.
that was our point, like, we're not trying to,
I understand.
yeah, not that there's a lot of
I
neighborhoods,
just
like,
wanna
right
make
next
that
to it.
clear,
Yeah,
that's all.
yeah. No, we never would expect it to, because there's no hotels around the outside, and obviously it only applies, the I-95 buffers only apply on I-95, so. Because there's actually a hotel north of the hotel, on the southbound exit ramp. That's a hotel property north of that, in the, I can't read that, in the pink zone.
Correct.
Sorry. C60, and I did not put a red line there intentionally, because that, I don't think the way it's written, it's only between hotels in the zone.
Good point. Thank you, sir.
Thank you.
Anybody wish any rebuttal time who spoke previously? Hearing none. I just have one more point I want to make during the public hearing. Of course, anyone else is free to speak. We're in the midst of rewriting the zoning regulations, and this matter will come up again for review. And just as any other existing item which is in the zoning regulations, it will be reviewed and could change again. So I don't think we have to cite that as a condition in the approval. It's just a right that we retain as we move through the process. So that doesn't, this doesn't have any special protection as it moves forward.
Yeah, for the record, Mr. Chairman, we understand that. And actually, knowing you were going through the process, I might have asked Clifton this, like, should we wait and maybe suggest it as part of a bigger global thing, or, go on our own? And it was decided to go on our own, because I know you guys are moving at your own pace. So.
It's still a significant period before we'll get there.
Exactly.
And I understand that, but I know you understand the process.
Yes.
It doesn't have a target on its back, nor is it, inoculated from further review and change. So.
Right, yeah. But I agree with you that that shouldn't be a condition of approval.
Thank you. Okay. What's the commission's pleasure on this hearing?
Mr. Chairman, I make a motion to close the public hearing.
Motion's been made by Ryan. Thank you, Aaron, to close the public hearing. Is there a second? Seconded by Lynn. Thank you, Lynn. Any discussion on the motion? Hearing none, all in favor?
Aye.
Anyone opposed? Any abstentions?
On the text amendment?
No,
On the
this is
motion to,
on the,
I'm sorry. I
motion
thought I
to
missed
close.
something there for a minute. Yeah.
Okay, chair votes aye on the motion to close. Meeting is, the public hearing is closed. What's the commission's pleasure on this application?
Mr. Chairman, I'd like to hear from Clifton, on that proposed amendment language you had regarding the 8.6.1. We're good.
Thank you. So in order to address the applicant's intent and the concerns raised by Lynn, a potential amendment for item B there would read, quote, "Minimum buffer requirements shall not be applied to property lines where a hotel use abuts an adjacent hotel use." End quote.
So let me just ask you, before we go there. You have a hotel, the hotel goes bankrupt, there's no buffer lines, the next business in there is not a hotel. What happens then? They built their parking lot, it's all black. What happens then? Are they expected to tear up the parking lot, put a buffer in for the store that goes in, or what, how does that work?
Potentially, depending on the scale of the development, which is the exact same thing that would potentially apply to the property in question. If they were going through the scale of development for this property to add that third story and reconfigure the parking lot layout, as written, they would have to apply a 50-foot buffer where there's one that currently doesn't exist, unless they went through the process for a variance.
But if they just changed the business?
They just changed the use, the way that the commission in Stonington has operated. Those uses can be reviewed by the zoning enforcement officer. If it's at a scale or intensity that requires additional parking or configuration of parking, which is usually the driving factor, then it would have to come back for a site plan approval or a special use permit depending. And in that case, then yes, it would have to be revised, unless again receives a variance.
And they'd have to go through
It would be
ZBA.
subject to review and approval of this commission.
Correct.
So you just
But they would
can't
not
just
have to go,
willy-nilly as, you know,
If they're
build a parking
small,
lot without
yep,
approval.
if they're small
But-
scale use changes that don't have that increase in intensity, then those can be signed off by the zoning enforcement officer currently. But if it's something that would require a special use permit, say, or they are reconfiguring the site to add more parking, then yes, those changes would start to apply, or those buffer requirements would start to apply.
okay. So they wouldn't have to go through ZBA for that? They would come to this?
Unless they wanted to keep it the same, and then in which case they would have to receive some form of variance in order to keep a non-conformity.
So, okay.
Anyone else have any comments?
I'd just like to say that, although I totally understand the 95, I think that there's a lot of gray area around this, a lot of nuances and loopholes that could really not fulfill the intent in the future. So, you know, I'd like to propose that what we talk about as, you know, a text amendment is that we just eliminate B in 6.8.1 rather than try to rejigger it on the
I think-
fly.
So Clifton, would you say your amendment would basically address, or would that address your concerns, Lynn? The amendment that Clifton outlined?
No,
Why not?
because I think, let me just get and unfortunately I didn't, because I think that, and I think this is just overall and probably should be discussed during the proposal, but, you know, we have an opportunity, that area of 95 is kind of the gateway into Mystic, and it's a mess, to be quite honest, and the property that has been highlighted is a mess. And I think, you know, this is an opportunity to say, no, okay, you can have the 95 buffers, which make complete sense based on the built out, but it's an opportunity for us to improve that area. And, you know, talking about sharing parking lots, et cetera, well, that's a what if. if the two people agree, if this, if that. Whereas if we allow a buffer, we've got some green there, you know, which again is another way to reduce impervious area. So I just think that we have a great opportunity to make this a better area rather than just saying, okay, we're just going to allow everything to exist as it is. So I personally think we shouldn't have B at all in there. I mean, it's a mess.
I can understand.
What's a mess?
That whole parking lot, the whole, you know, the way you come off 95, there's just garbage all over the place. There's no greenery on that side of the road whatsoever. You know, it doesn't, I think, reflect our community. You know, according to the POC, you know, we're supposed to be enhancing tourism. I don't think it really is visually a great gateway into Mystic, that whole intersection area at all. So I think it kind of goes against the POCD.
Just a quick question. Will the modifications that were discussed by the attorney require a special permit modification?
They'll come back for site plan review.
Site plan review. So there'll be an opportunity to look at the issues that we just discussed.
For that specific parcel, yes.
Yeah, for that parcel. And as talked about, you know, the chances of having another hotel up top, well, who would have thought that the Seaport would have had a hotel, right? Who, you know, I just think that you have to think of sometimes the overall build-out of an area when you're talking about a zone change, not what's specifically in front of you today. And I think this is a little myopic, to be honest with you.
But we haven't acted on it yet, so.
No.
I'm just trying to understand your objection. And please don't misunderstand my comments about saying that, you know, the previous problems exclude a hotel from further consideration. We could get that application next week. I agree.
Exactly.
I agree. It's just that any sort of intensive use on that parcel is going to require fire suppression, it's going to require storm sewers.
It's going to be difficult.
Require, and stormwater management, and it's going to require sanitary sewers. And so those three significant obstacles remain. And they impose a huge economic requirement to meet the standards there. So I'm not as worried about that parcel as I am some of the other things that you just mentioned. But I do know that we also have site plan review and more detailed site plan requirements associated with special permits. And most of the intensive uses require special permits and site plan approvals. And there we have tremendous discretion to address the issues that you just spoke of.
But why leave it to that? Like, why leave it to an individual site plan review when we have the, I mean, it's like we're saying, yeah, but we'll do it. I'd like to say we're not going to do that. We're not going to have, you know, no buffers between commercial entities, including hotels. I mean, why should hotels be different from anything else? Just between, yeah, go ahead.
So I think we have an example of where these requirements are not imposed, these buffer requirements are not imposed, and that area isn't a mess. So we have an example of where these requirements exist, and it hasn't contributed to mayhem.
I'd just like to say also that, so the current text has the 50 feet of screening between adjacent hotels, and we're talking about completely eliminating that buffer? What if it was reduced to 10 feet? And my reason for kind of leaning towards allowing this is because I'm thinking they want to put a third floor on, and we have this huge problem with short-term rentals in town. And I think, you know, hotels specifically should be encouraged, because that may be a way to take some of the pressure off of that other thing. I don't, it's all very complicated, but
Yeah,
I think if they can add a third floor,
I would say if I can too, and I think, I understand your concern, Lynn, and I get it. I also think that we can't act in what I would almost consider a punitive manner and say, because we don't like the current layout, we're gonna deny the applicant something that I think with some good stipulation is reasonable for what they're asking. So I think it would help that area. I don't think we can totally redesign that area. This particular amendment's not gonna do that, whether we allowed it or not. It's not gonna change what's there. I think it's going to allow some better uses there. And, to your point, I think it would also, increasing the hotel space is going to help on the short-term rental kind of side of things as well, I think. That's just my opinion from what, just listening to this and reading it, and I do think that amendment would protect us specifically on the boundary lines, but. I
But
understand your
putting,
concerns.
but putting
I-
a third, oh, go ahead.
We have to work through the chair, okay? Just, that's the best way to moderate a discussion like this. And I agree with what you said. I don't like to raise hypotheticals unless, there's a realistic example associated with it. Because it just, I don't think it's necessarily fair to the applicant or fair to the town to deal in hypotheticals unless there's some reason to back that up, and it's more than a hypothetical, it's a possibility. And I agree with the comments that you just made. Yes, Lynn, thank you.
Yeah. So, Chuck, I think I agree with you, except when you're talking about a text change in a zone and not just an individual build-out, right? A text change in a zone, you have to think of the hypotheticals because it's open to anything at that point. I'm not sure that requiring any kind of a buffer between two hotel sites is going to, especially one where we're talking about raising a third floor, is going to make it so you can't put a third floor on that building.
I think I agree with Chuck that making a decision based off of hypotheticals property specific when technically we shouldn't be considering a singular property is probably not the best directive. But in the case that you're highlighting specifically, that parcel, its configuration, adding in a buffer, your limiting factor, because the way our regulations are written, is always going to be parking. So unless you can come up with a tangible parking solution in that area, then you are effectively limiting the development output because you wouldn't have enough parking spaces to meet that use. So that site singularly specific, yes, that applying a buffer here in that format would actually prohibit the development of that site, in which case they would have to go before the ZBA as written in order to alleviate that.
So I just don't think a text change for one site makes sense to do that. I don't. And I think it's to say, well, we want to be able to expand and we don't have another solution, or have we even thought about another solution for the parking issue, so we're going to ask for a text change is kind of a big ask.
It was the advisement of myself and staff to proceed with the text route before the ZBA, because ZBA is your last resort.
Right.
So this would be the natural first step that they would have to go through. So they are following the proper process and are starting to exhaust their options.
Right.
There's no further discussion.
Chuck, if I may, I think it sort of is a single use, but it's also, we talked about, having a greenway, and we don't care about 95, but we do care about next door. So you're eliminating green space next to 95, but you care about the space, which is now non-conforming, so it's a 5-foot wide piece of gravel in between two parking lots. And extending that into a 30-foot wide green space by removing a 30-foot wide, space next to 95, I think you're stifling, the overall problem of, trying to, if you have an old building that needs, some work and some love into it, by saying no immediately, nothing will ever change. So this is, a great idea to.
Yeah, I was going to say, Mr. Chairman, the alternates aren't supposed to be speaking.
I was going to bring that up. Alternates are not supposed to speak during this portion of the meeting, but
I apologize.
appreciate your comments.
I was going to say something, but I bit my tongue.
I was an alternate once. It's a difficult spot to sit in. Anyone else like to make any comments?
I mentioned it being the gateway and garbage being there. I don't know what garbage there has to do with this hotel. We can't blame the hotel owners on garbage there, the aesthetics there. And as far as tourism, I got news for you. If these hotels both renovate, it's gonna look better, way better than it looks there now, just based on free market, doing what the free market will do.
I don't
So-
think this is a deal breaker for either one of those hotels being renovated. So I just want to state that right off the bat. This is not a deal breaker. Those hotels will be renovated, whether they have the Section B amendment or not. And there'll be an improvement. This is our opportunity to make sure there's a little bit of green, a little added green to that area.
I agree that that's a valid situation. We know we're looking at coverage limits in the zoning regulations, and eventually that will apply here. Impervious coverage is going to be added, and that's a very important element, and I'm a proponent of that. I guess because there's a site plan review process and we look at things like stormwater management has to work. You can't just pave an entire site and make the stormwater management work anymore under low impact design standards. So I think there's a number of review factors in the course of even a simple site plan that come into play that preclude, the old property line to property line blacktop, which I agree with you, doesn't add to the charm of the area at all. And again, I'm a proponent of that, so. Anyone else have any comments? If not, what's the commission's pleasure on this application?
Mr. Chairman, I make a motion to approve the application with the following stipulation, and please, Clifton, correct me if I'm wrong, my handwriting might not have caught everything. I would make a motion to approve the application with the stipulation that the minimum buffer line shall not be applied to the boundary lines. Is that correct?
Correct.
Okay.
So motion made to approve with conditions. Is there a second? Thank you, Ryan.
Just for clarification, that just you're referring to the entirety of what I said?
Yes.
Okay.
Yes.
Thank you, Clifton. Is there a second to the motion to approve with conditions?
I second the motion.
Seconded by Gary. Thank you, Gary. Any discussion on the motion? Hearing none. Should probably go in order here. Andy, why don't you vote first?
I will vote in favor of the amendment.
Deny.
And this against? Gary?
In favor.
Ryan?
In favor.
And the chair votes aye on the motion. And so it passes with one member opposed. We have item 9 on the agenda, future public hearings. Clifton, any information on that we should be aware of at this point?
Nope.
Okay, that concludes the items for consideration this evening. Appropriate motion to adjourn, I believe, is in order.
Mr. Chairman, I make a motion to adjourn the hearing, or the meeting, sorry.
Thank you, Ryan. Thank you, Lynn, for the second. All in favor of the motion?
Aye.
Chair votes aye. Meeting is adjourned. Thank you.